Good morning, Canada. Alex Monahan here, Foundations Party, ineligible. And today's date is April 13th, 2017. And we are going to continue reading the Immigration Refugee Protections Act. And we left off on paragraph 37, organized criminality. So, subsection 1 of paragraph 37 is a permanent resident or a foreign national is inadmissible under grounds of organized criminality for A. Being a member of an organization that is believed on reasonable grounds to be or to have been engaged in activity that is part of a permanent partner of criminal activity planned and organized by a number of persons acting in concert in furtherance of the commission of an offense publishable under an act of Parliament by way of indictment. Excuse me. Might be a little choppier today than it was yesterday. Or in furtherance of the commission of an offense outside Canada that, if committed in Canada, would constitute such an offense, or engaging in activity that is part of such a pattern, or B. engaging in the context of transnational crime in activities such as people smuggling, trafficking in persons, or laundering of money or other proceeds of crime. Applications. Paragraph 2. Paragraph 1A does not lead to a determination of inadmissibility by reason only of the fact that the permanent resident or foreign national entered Canada with the assistance of a person who is involved in an organized criminal activity. Health grounds. 38. A foreign national is inadmissible on health grounds if their health condition A. is likely to be a danger to public health, B. is likely to be a danger to public safety, or C. might reasonably be expected to cause excessive demand on health or social services. Exception. Subparagraph 2. Paragraph 1C does not apply in the cases of foreign nationals who A. have been determined to be a member of the family class and to be the spouse, common law partner, or child of a spouse within the means of the regulations. B. has applied for the permanent residence visa as a convention refugee or a person in similar circumstances. C. is a protected person, or D. is, where prescribed by the regulations, the spouse, common law partner, child, or other family members of a foreign nation referred to in any of paragraphs A to C. Financial reasons. Paragraph 39. A foreign national is inadmissible for financial reasons if they are or will be unable to or unwilling to support themselves or any other person whom is dependent on them, and have not satisfied an officer that adequate arrangements of care and support other than those that involve social assistance have been made. Misrepresentation, paragraph 40, subparagraph 1, a permanent resident or a foreign national is inadmissible for misrepresentation, A, of directly or indirectly misrepresenting or I'm tongue-tied today, or withholding material fact relating to a relevant matter that induces or could induce an error in administration of this act. B, for or having been sponsored for a person who is determined to be inadmissible for misrepresentation. C, on a final determination to vacate a decision to allow their claim for refugee protection or application for protection. Or D, on casing to be a citizen under paragraph 10(1)(a) of the Citizenship Act, as it reads immediately before coming into force of Section 8 of the Strengthening Canadian Citizenships Act in the circumstance set out in subsection 10(2), and the of the Citizenship Act, as it read immediately before that coming into force. 2. Subsection 10(1) of the Citizenship Act in the circumstance set out in subsection 10.2 of this Act, or 3. Paragraph 10.13 of the Citizenship Act in the circumstances set out in sections 10.2 of this Act. Applications, subparagraph 2. The following provisions govern subsection 1. A, a permanent resident or a foreign national continues to be inadmissible for misrepresentation of a period of 5 years following in a case of a determination outside Canada, a final determination of inadmissibility under sections 1, or in the case of a determination in Canada. The date of removal order is enforced, and B, paragraph 1b, does not apply unless the minister is satisfied that the fact of the case justifies the inadmissibility. Inadmissibility, subparagraph 3. A foreign national who is inadmissible under this section may not apply for permanent residence status during the period referred to in paragraph 2a. Cessation of refugee protection. Foreign national. Paragraph 40.1, subparagraph 1. A foreign national is inadmissible on a final determination under subsection 108. 2. That their refugee protection has ceased. Rearrange myself here a little bit. Subparagraph 2, a permanent resident is inadmissible on a final determination that their refugee protection has ceased for any of the reasons determined in paragraphs 108(1)(a) to d. Non-complaint with Act. 41. A person is inadmissible for failing to comply with this Act. A. In the case of a foreign national, thought through an act of omission with contraventions directly on or indirectly provisions of this Act. B. In the case of a permanent resident through failing to comply with subsection 27(2) to subsection 28. Inadmissibility family members. Paragraph 42, subsection 1. A foreign national other than a protected person is inadmissible on grounds of inadmissibility family members if A. Their accompanying family members, or in proscribed circumstances their non-accompanying family members, is inadmissible, or B. They are an accompanying family member of an inadmissible person. Exception, subparagraph 2, in the case of the foreign national referred to in subsection 1, who is a temporary resident or who has made an application for temporary resident status, or an applicant to remain in Canada as a temporary resident. A. The matter referred to in paragraph 1A constitutes inadmissibility only if the family member is inadmissible under section 34, 35, and 37. And B. The matter referred to in paragraph 1B continues inadmissibility only if the foreign national is and accompanied by a member of a person who is inadmissible under section 34, 35, or 37. Exceptions, applications of minister. 42.1, subparagraph 1. The minister may, on application by a foreign national, declare that the minister referred to in section 34, paragraphs 35(1)(b) and c, and subsections 37(1) do not constitute an inadmissibility in respects on the foreign national if satisfied by the minister that it is not contrary to the national interest. Exceptions, minister's own invitations. Subparagraph 2, the minister may, on the minister's own invitation, declare that the ministers referred to in section 34, paragraph 35(1) and 35(1)(b) and c, and subsections 37(1) do not constitute inadmissibility in respects of a foreign national if the minister is satisfied that it is not contrary to the national's interest. Consideration, subparagraph 3, the determination whether to make a declaration, the minister may only take into account national security and public safety considerations, but in his or her analysis, it is not limited to considering the danger that the foreign national presents to the public or the security of Canada. Regulations, paragraph 43. The regulations may provide for any members relating to the application of this division, but may define for the purposes of this Act any of the terms used in this division, and may include provisions respecting the circumstances in which a class of permanent residents or foreign nationals is exempt from any provisions and divisions. turn the page. Oh, actually, and I think that'll be all for this section today, or this part, and we will pick up the second part in Division 5. Thank you for listening, and I hope you enjoy the next one.